The ambiguities surrounding the House's abuse of power theory give this senator reason enough to vote not guilty. For the many ways in which the House failed in the fundamentals of oversight, and for the terrible new precedent this obstruction article would set, I'll vote not guilty.
I did my constitutional due diligence. I read the House manager's brief and those reports prepared by the House Republicans and the President's counsel. I saw it all in black and white, and it was my due diligence that has led me to support acquittal.
The reasons behind why the president should not be impeached are common sense. He didn't commit a crime. And that came not just from me, you'd expect me to say that. That came from others that were the well-respected attorneys that were involved in each side of this case. In each of the past impeachment cases in the House of Representatives accused the president, Johnson, Nixon, and Clinton, of committing a crime.
I say enough. Let's put our trust in the American people. They are the ones who should make the judgment about the president, and they will do that in 9 months. Let's not be so arrogant as to take that decision away from the American people.
The Constitution provides for impeachment, but does not demand it in all instances. An incremental first step to remind the president that, as Montesquieu said, political virtue is a renunciation of oneself.
The framers gave our nation an ultimate tool for evaluating the president's character and policy decisions. They're called elections.
While we can debate the president's judgment when it comes to his dealings with Ukraine, or even conclude that his actions were inappropriate, the House's vague and overreaching impeachment charges do not meet the high bar set by the founders for removal from office. The House could have challenged the president's privilege claims by going through the traditional channel to resolve disputes between the executive and legislative branches, that being, of course, the courts.
The judiciary resolves disputes between the executive and legislative branches. The House should have exhausted judicial remedies before bringing this charge. I shall vote against Article 2. To remove a president, the crime must reach a high threshold of severity. The allegation against President Trump was not proven beyond a reasonable doubt, and it does not meet that high threshold. I shall vote against Article 1.
The arguments of the House manager simply did not demonstrate that the president's actions rise to an impeachable offense. Given the constitutional requirements, voting any other way on these articles would remove the ability of the American people to make their own decision at the ballot box in November.
I will vote not to convict. I will do so because there's not overwhelming evidence, because no high crimes are shown, because there's not a broad consensus among my countrymen, only articles passed on a narrowly partisan basis, and because removing President Trump on these charges at this time would set a dangerous precedent.
During the proceedings, I asked a question that was disallowed.
After 2 weeks of trial arguments, the House managers failed to make a compelling case that the president should be removed from office. Therefore, I will vote for the president's acquittal.
I have concluded that the arguments and evidence do not provide me with a sufficient rationale for reversing the 2016 election and removing President Trump from the ballot in 2020.
After performing my due diligence, along with many others, and considering all assertions by the House and Senate managers, I believe the President should be acquitted from both charges. I do not believe that removal from office is warranted, more especially during an election year.
It is clear to me that the House should not have impeached President Trump, and the Senate should vote to acquit the President.
It is true that the Trump administration temporarily delayed aid to Ukraine. Does a president have the constitutional authority to investigate credible allegations of corruption?
Anyone who knows a law book from a J. Crew catalog does not take this charge seriously. Executive privilege and testimonial immunity are well-established, constitutionally based presidential and executive branch privileges that every president at one time or another has asserted. The House Democrats, claiming to be able to read the president's mind, say that the president did it with a corrupt motive because the investigation of corruption was against former President Joe Biden, a political rival. But the president didn't get Joe Biden's name out of a phone book.
It's clear now, after hearing all the testimony, that the primary motivation to ask Zelensky to look into the Biden-Burisma corruption issue was to root out corruption in the Ukraine. Arguing that President Trump obstructed Congress by claiming his rights is unacceptable and would fundamentally weaken this right for future presidents.
I am voting to acquit President Donald J. Trump. For the good of our country, let it be seared in our minds forevermore. Impeachment must never, ever again be used as a partisan weapon. In the first article of impeachment before the Senate, the question is whether abuse of power as a charge on its own is an impeachable offense. The answer is no. In the second article of impeachment, the House alleges the president obstructed Congress when he refused to comply with congressional subpoenas. The president rejected the legitimacy of those subpoenas. No branch of government is above the Constitution.
It was wrong for President Trump to mention former Vice President Biden on that phone call, and it was wrong for him to ask a foreign country to investigate a political rival. The House did little to support its assertion in Article 1 that the president will remain a threat to national security and the Constitution if allowed to remain in office. Article 2 seeks to have the Senate convict the president based on a dispute over witnesses and documents between the legislative and executive branches. As a general principle, an objection or privilege asserted by one party cannot be deemed invalid, let alone impeachable, simply because the opposing party disagrees with it.
I've consistently said that the president asking Ukraine for an investigation of Joe Biden was inappropriate and wrong. I've also said since then that any actions taken by members of the administration or those outside the administration to try to delay military assistance or a White House meeting pending an investigation by Ukraine were not appropriate either. But while I don't condone this behavior, these actions do not rise to the level of removing President Trump from office and taking him off the ballot in a presidential election year that is already well underway.
Beyond whether the president's conduct met the high bar of impeachment, there is also the underlying issue of the legitimacy of the House impeachment process.
To be clear, the partisan nature of this impeachment process potentially sets the stage for more impeachments along strictly partisan lines. In just a few months, the voters of this country will get to decide who they prefer to lead our country. I trust them to make that decision. And I trust that the process by which we choose our president and other leaders will remain free and fair, and that the outcome will represent the will of the people.
The abuse of power argument hinges on two things. Did the President of the United States use official funds to compel the Ukrainian government to investigate Joe Biden's son and his work for the corrupt natural gas company in Ukraine, Burisma? And did the President withhold a meeting with President Zelensky until President Zelensky agreed to investigate Joe Biden's son? To be clear, the theory of the funds being withheld from Ukraine in exchange for an investigation doesn't originate from that now infamous July the 25th call. There's nothing in the text of the call that threatens the withholding of funds for an investigation. The House argument was the President didn't turn over every document and allow every witness without submitting everything to Congress immediately. They argued that if the President challenged any subpoena, he was stalling, he was acting guilty, and so it was grounds for impeachment. Remember how fast this all happened. This tale that President Trump thinks he's a king and he doesn't want to follow the law begs reality.
House Democrats allege that the president withheld military aid from Ukraine in exchange for investigations of Joe and Hunter Biden. But they failed to bring forward compelling and unassailable evidence of any crime. Removing the president from office for asserting long-recognized and constitutionally grounded privileges that have been invoked by both Republicans and Democrat presidents would set a very dangerous precedent and would do violence to the Constitution's separation of powers design. In effect, it would make the presidency itself subservient to Congress.
The House Democrats have given us the first purely partisan impeachment in our history, and the first attempt to remove an elected president that does not even allege unlawful conduct.
I worked with other senators to make sure that we had the right to ask for more documents and witnesses, but there was no need for more evidence to prove something that I believed had already been proven and that did not meet the United States Constitution's high bar for an impeachable offense. There was no need to consider further the frivolous second article of impeachment that would remove from the president and future presidents, remove from this president for asserting his constitutional prerogative to protect confidential conversations with his close advisors.
The legislative branch cannot also be the judicial branch. The legislative branch can't also decide, here's the balance. Executive and legislative branch are in a fight about what should be disclosed and what shouldn't. You can't continue to have the three balances of power in our government if one of the branches can decide what the legislative branch should decide. These articles should have never been sent to the Senate. They were not compelling, they were not overwhelming, they were not bipartisan, and most importantly, Mr. President, they were not necessary.
He momentarily paused U.S. aid to Ukraine while seeking a commitment from the then newly elected Ukrainian President Vladimir Zelensky regarding that effort. He wanted to make sure that he could trust this recently elected President Zelensky before sending him the aid. The very first section of Article 2 of the Constitution, this is the part of the Constitution that outlines the president's authority, makes clear that the executive power of the United States government shall be vested in the President of the United States. It's important to remember that there are exactly two federal officials who are elected within the executive branch of government. One is the Vice President, and the other is the President. The Vice President's duties, I would add, are relatively limited. Constitutionally speaking, the Vice President is the President of the Senate, and thus performs that in a quasi-legislative role. But the Vice President's executive branch duties are entirely bound up with those of the President. They consist of aiding and assisting the President as the President may deem necessary, and standing ready to step into the position of the presidency should it become necessary as a result of disability, incapacitation, or death. Barring that, the entire executive branch authority is bound up within the presidency itself. The President is the executive branch of government.
Even under the cloud of purely partisan politics of the House of Representatives, the Senate conducted a complete, comprehensive trial, resulting, in my view, in a crystal clear conclusion. Whether he's acquitted or convicted and removed, it's my prayer, as we were admonished many times throughout the last few weeks by our chaplain Black, that God's will is the one that will be done.
Those prosecuting the president failed on a legal and constitutional basis to produce the evidence required to undertake the very serious act of removing a duly elected president from this office.
I come at this with a little bit of a different view than probably others. I've tried more cases probably than anyone on the floor, both as a prosecutor and in private practice.
Rules are rules. They're there to be followed. Let's vote no on these motions today and get back to working for the American people.
The framers consciously diluted each branch's power, making all three separate but equal, empowered to check each other. The obstruction charge assumes the House is superior to the executive branch. In their zeal, the House managers would disempower the judiciary and demand that the House's interpretation of the sole power of impeachment be accepted by the Senate and the other branches without question. At the outset, this case does not set the precedent that a president can do anything as long as he believes it to be in his electoral interest. I also reject the claim that impeachment requires criminal conduct. Rather, this shows first that House committees cannot simply assume the impeachment power to compel evidence without express authority from the full body and corresponding political accountability.
Even if the facts are as they have stated, the managers have failed, I believe, as a matter of constitutional law to meet the exceedingly high bar for removal of the president as established by our founding fathers. The House manager's obstruction of Congress claim is similarly flawed. Congress's investigative and oversight powers are critical tools, and we use them in ensuring our system of checks and balances.
Impeaching this president, you've made it almost impossible for future presidents to do their job. You're impeaching the President of the United States for suspending foreign aid for a short period of time that they eventually received ahead of schedule to leverage an investigation that never happened.
In this article of impeachment, 48 senators have pronounced Donald John Trump, President of the United States, guilty as charged. 52 senators have pronounced him not guilty as charged. 2/3 of the senators present not having pronounced him guilty, the Senate adjudges that the respondent, Donald John Trump, President of the United States, is not guilty as charged in the first article of impeachment. On this article of impeachment, 47 senators have pronounced Donald John Trump, President of the United States, guilty as charged. 53 senators have pronounced him not guilty as charged. 2/3 of the senators present not having pronounced him guilty, the Senate adjudges that respondent Donald John Trump, President of the United States, is not guilty as charged in the second article of impeachment.
Mr. Romney. Mr. Romney, guilty. Mr. Barrasso. Mr. Barrasso, not guilty. Mr. Braun. Mr. Braun, not guilty. Mr. Burr. Mr. Burr, not guilty. Mr. Cotton. Mr. Cotton, not guilty. Mr. Crapo. Mr. Crapo, not guilty. Mr. Enzi. Mr. Enzi, not guilty. Mr. Johnson. Mr. Johnson, not guilty. Miss McSally. Miss McSally, not guilty. Mr. Moran. Mr. Moran, not guilty. Mr. Rubio. Mr. Rubio, not guilty. Mr. Sass. Mr. Sass, not guilty. Mr. Scott of Florida. Mr. Scott of Florida, not guilty. Mr. Sullivan. Mr. Sullivan, not guilty. Mr. Tillis. Mr. Tillis, not guilty. Mr. Toomey. Mr. Toomey, not guilty. Mr. Young. Mr. Young, not guilty.